Okay, Mr. Adams, you're up. Can you hear me?
You're on mute.
Mute. I'm not on mute.
Nope, Mr. Adams is on mute. I'm
Adams.
sorry.
Yeah. I didn't
There you
realize
go.
he was speaking.
We can't hear you.
We cannot hear you, Mr. Adams. Oops.
All right, this is Eric Adams, and I apologize for my
There you
tech.
go.
Oh, that's okay.
I was attempting to be high-tech and use a wireless headset in an effort to make sure the court could hear me better, and of course, the court has seen how that backfired, and I apologize.
We can't hear you very well now.
Well, and that's not it's not how I dreamed this would work, but I hope you can hear me a little bit better.
That's a little better.
Yes, sir. I'm going to start in just a second here, and hopefully I've opened up my laptop, and hopefully the court can hear me a little bit better now too.
That's good.
Awesome. Thank you, Your Honor. My name is Eric Adams. I represent John DeRosiers, and I'm with the law firm of Schutz and Bowen. And I would like to, with the court's permission, reserve 5 minutes for rebuttal.
Sure.
Thank you, Your Honor. I'm going to explain a little bit of the background of the litigation that we're dealing with here, Your Honors, primarily because what happened in the underlying litigation is important for purposes of the post-judgment attorney's fees litigation that we're dealing with here. And the reason why that's important is it's the nature of the claims. This has its origins, or this lawsuit has its origins in lawsuits related to two notes. John was building a home in Sarasota, and I call my client John DeRosiers John because there's a Joanne DeRosiers, and it's just easier to say John and Joanne. I'm not intending any disrespect to the parties. He borrowed $200,000, one time from a family company called Conservatory, and one time from his mother to complete a home that he was building over in Sarasota. Neither note, neither one of them were drafted by lawyers. Neither note had a due date. They both were triggered by the sale of the home that John was building. The first note with Conservatory did not have a fee provision. The second note with Joanne did have a fee provision. Joanne and Conservatory filed two separate suits. Each suit sounded in breach of contract based on the express terms of the note, reformation in an effort to impose either because of mutual mistake, well, primarily because of mutual mistake, a end date for the note or repayment date for the note, and then a money lent count. Both complaints were nearly identical, so they were consolidated by the trial court down in Sarasota, Judge Rochelle Curley, and they were consolidated for both discovery and trial. John did assert a counterclaim only against Conservatory for both specific performance and a statutory accounting claim under Chapter 607. The results are important here because that's what dictates the post-judgment litigation that we're dealing with here. Joanne and Conservatory prevailed on their reformation counts. They prevailed on their money lent counts, and they prevailed based on the statute of limitations with John's specific performance count. But John prevailed on a breach of contract count, and John prevailed on the statutory accounting. And so the only claims where fee provisions are provided for either by the contract or a statute are those provisions on the counts which John prevailed. None of the provisions in which Joanne or Conservatory prevailed called for or had any sort of attorney's fees provision. So we find ourselves with John's renewed motion for attorney's fees, which is the operative pleading here, and that renewed motion for attorney's fees in the consolidated case. So one motion was filed for both consolidated cases. John asked for prevailing party attorney's fees under the Joanne note, and John asked for statutory attorney's fees under the 607 statutory accounting, and John asked for attorney's fees as to the Conservatory case based upon a proposal for settlement, and that request was later withdrawn. So the good news is this court doesn't find itself with any need to have argument related to the sufficiency or insufficiency of a proposal for settlement. But we are left with a unique question here. When we have mixed causes of action, some which provide for attorney's fees and some which don't, and you have prevailing parties who do not recover on all of their claims, so there's not homogeny in the results. The question is, who gets their attorney's fees and what's the test? And I would submit to this court, and the relief that we're asking for here is we're asking for this court, well, I'll rewind. The trial court ruled and said that upon motions for rehearing that John was not entitled to the contractual attorney's fees because he was not the significantly prevailing party in this particular litigation. And I would respectfully submit that the court skipped a step, the trial court skipped a step. And the first thing that the trial court should have done in following with either Olson or Lochrain from the Fifth, and even from the progeny of the Florida Supreme Court in Moritz, should have done an initial analysis which says, okay, was the breach of contract claim separate and distinct from the claim that was asserted related to the money lent or the reformation count? And I would submit to this particular court that it was separate and distinct. And the trial court, in not performing that initial analysis and jumping just to who was the significantly prevailing party and applying the Moritz test, skipped an important test. And had it applied that test, the outcome would have been different. And there would have been a determination, or should have been a determination from the trial court, that John DeRogers was entitled to his statutory attorney's fees, his contractual attorney's fees under the Joanne Note. This is a unique case that also has a cross appeal that Mr. Hauser's filed on behalf of his clients, suggesting that somehow the motions for attorney's fees were frivolous and violative of 57-105. I'm going to address some of those issues in our initial argument, but I'm going to address additional issues in the rebuttal time that I've saved, and I can address those particular issues. John's, despite representations to the contrary by Mr. Hauser in the cross appellant's brief, John's motion for attorney's fees was timely filed. Now there is
Mr. Adams, before you get into that, can I back you up just a little bit, because I'd like to unpack a little bit of your analysis and your brief's analysis on that first. I'll call it the first factor, whether or not claims are sufficiently distinct. As I read your brief, I was left with the impression that the analysis you would propose is basically, look, if a cause of action has distinct elements from another cause of action, then it's separately distinct. The problem with that approach, to my mind, is that it's a rule that swallows all within its ambit. Anytime you have a separate count, you're going to necessarily have distinct elements of a distinct cause of action kind of a priori. So what is kind of a unified, what you would propose as a unified comprehensive test that a trial court could look at different causes of action counts and conclude from that yes, these are indeed separate and distinct for purposes of running the analysis that you propose?
And it's not an easy analysis, and I don't envy this court's particular position, nor do I envy Judge McHugh's position. But I think the test in the district courts of appeals in determining whether or not something is a separate, distinct claim is whether or not there are different allegations of wrongdoing and different elements of proof. And I would submit that on both the reformation claim and on both the breach of contract claim and on the money lent claim, there were different allegations and different elements of proof. It's not enough to bundle them all together just because they arise out of the same steps. That's not enough, and that's what Olson and Lochrain say. Olson and Lochrain were about someone modifying their property, or Olson at least was about someone modifying their property and causing water to flow and creating a nuisance condition. And in that situation, the homeowners association won on the nuisance condition, but the homeowner himself, who Mr. Hauser represented in that particular appeal, won on all of the Chapter 720 claims that had statutory causes of action. So there was a mixture that was there. But in that particular situation, the Fifth DCA determined and discussed the Moritz analysis and determined that there were separate and distinct claims because there were different allegations of wrongdoing and different elements of proof. Here, with respect to the reformation claim, Florida law is very, very clear under the second DCA case from 1981 that we cite in our brief, Natarajan versus Horn, that reformation is separate and distinct from John's breach of contract claim here. And I would submit that normally maybe a money lent count and a suit on a note might have similar allegations, but not here. If you had a note that had a due date and you had a note whose default was non-payment, then I think that they would merge, and I think that you'd have a common cause of action that wouldn't be separate, distinct. But here,
I mean, let me pitch something. I'm curious about that reformation, because my initial reaction as I was reading, just being candid, is that wait a minute, how is a reformation of a contract action separate and distinct from a breach of contract action? How can you really say that it's the same parties? It's all you're doing is changing something. Suppose you had a situation where the only thing that was being reformed was a due date on one payment of 20 payments, right? And for whatever reason, that one payment did not get clear, wasn't clearly set forth, but the parties needed to get it reformed to jive up with everything else. So you have this one payment date clarified in a reformed way, such that the contract is reformed reflect what the parties may have discussed, but for whatever reason, again, didn't get into the ultimate contract. Could you really say that that's just a completely separate and distinct cause on the reformation count, as opposed to another, let's say, breach of payment number 18 or 19 count that gets brought as legal action? You see where I'm driving at?
I absolutely do. And respectfully, Your Honor, I think under your hypothetical factual scenario, it becomes a closer call. But in this situation, it's not a close call, because there was not a non-payment allegation, a breach allegation inside of the breach of contract claim. It was you didn't do what you were supposed to do to try to sell the house. You breached some sort of duty of good faith and fair dealing. There were different allegations that were there because they couldn't, and that's why they lost on the breach of contract claim, both Joanne and conservatory. And so if it had just been a non-payment related issue or a minor checking of a box, but when we really Judge Curley's first and second and original first and second amended final judgment, it was very, very clear that because if this had just been a box checking issue, they would have won on the breach of contract claim, but they didn't because of the nature of the allegations and because of the nature of the proof and the differences and the issues that are there. And I would respectfully submit that the money lent count did not also arise out of the contract. Yes, it was the same commercial transaction, 2 $100,000 loans, but the money lent and the elements there in following the Florida Supreme Court are relatively straightforward and simple. But here, the allegations, and you can find this on the record on page 13, is that the allegations of breach was that there was a failure on the part of John DeRosiers to make all reasonable efforts to market, list, and sell the property in a timely manner, and by listing it at unreasonably high prices. That's their breach of contract count. And that's nothing like the money lent count. And so when we look at the analysis under Lochrain or under Olson, we can arrive at the same conclusions. And the significant issues of Moritz, it's important to look at the Moritz case from 1992 in the Florida Supreme Court. In Moritz, on which both Joanne and conservatory significantly rely, that was two parties making a claim on either side of the same coin, a contract. And it's easy to look at in the weighing because they were inside of the same bucket. They're suing over the same contract. They're suing over the same issues. And that's where this significant issues test arises out of. But when we look at Olson, or we look at, which was a multi-count complaint, or we look at Lochrain, which was a tort, implied warranty, and breach of express contract complaint, they all arise out of a similar transaction, a similar relationship. But there, where a plaintiff, for example, in Lochrain, where a plaintiff prevailed upon implied warranty and a defendant prevailed upon tort and contract, it was a mixed bag. And they didn't get to that substantial factors test. And the reason why they didn't get there in Lochrain or they didn't get there in Olson is because they determined that the claims they had different elements of proof and they had different evidence that was relied upon. And so our submission, respectfully, is that the court meaning the trial court, should have looked at and done the analysis, and we would submit on a de novo basis because it is a legal analysis for this court, but this court could do that today if it so chose. And I would submit to the court, especially when we look in the language under head notes 1, 2, and 3 of the Olson opinion, the distinguishing nature there from the present case is that you don't get to the significant issues test. Now, Olson went on and did the analysis of what if we got to the significant issues test, but the holding of Olson is one where you don't have to get there if you determine, and we would submit that's what the ruling that we're asking the court to do here today. And in quoting in Lochrain, I think this is the most instructive, where a plaintiff in a multi-count complaint asserts a claim to which is a provision for fees and asserts other theories of recovery which do not include a provision for attorney's fees, one party or the other party is a prevailing party as to the cause of action involving those fees, independent of which party wins or loses on the other theories of recovery asserted in the same case. And that's what we're asking the court to do here today. There is a suggestion, Your Honors, that the fee motion filed by John on the contractual issue was insufficient, and this is something that's raised on the cross appeal that was filed by conservatory or by Joanne, because it didn't specifically cite 57-105 sub 7. But we have relied upon in our brief and outlined to the court why it is that the one-sided attorney's fees provision inside of the Joanne note is statutorily transformed, turning that unilateral attorney's fees provision into a contract provision that's reciprocal. And when we talked about this particular issue inside of our fee motion, our renewed fee motion, it's at 519 in the record in paragraph 21A. We talk about relying upon the fee provision inside of the Joanne note. And we were able to rely upon that because it became reciprocal or bilateral by statutory transformation. Mr. Hauser has suggested that the motion, John's motion, was either insufficient or maybe frivolous because of his failure to cite 57.105 sub 7. And I would submit to this court that's not necessary. And the reason it's not necessary is because it is statutorily transformed. And we relied upon the Bank of New York Mellon Fitzgerald case of 215 Southern 3rd, 116. Even plaintiffs, Conservatory and Joanne's supplemental authority that was filed a few weeks ago supports this. The Levy versus Levy family law case, which is the third DCA case from July of 2020, states that by operation of law, 57.105 sub 7 amends by statute all contracts with the prevailing party fee provision to make them reciprocal. And so I would submit that the motion was timely, the motion was sufficient and appropriate, and the motion, should have been granted because the causes of action were separate and distinct based upon both the element issues as well as the evidentiary issues. With
Mr.
respect,
Adams, you are at your 15-minute mark. So use the rest of your time as you please.
I will reserve. Thank you, Your Honor.
Mr. Hauser?
Thank you, Your Honors. John's appeal would make George Orwell blush. There is a pattern by John of filing bad faith or frivolous motions and making frivolous arguments. I do not say this lightly. For example, John made a $100 offer of judgment to Conservatory. After Conservatory recovered a $152,000 judgment, John made a bad faith motion for attorney's fees based on that offer of judgment, even though the amount recovered was 1,500 times more than the offer. The trial court found that John filed a 1.5525 motion against Conservatory based on the contract that did not have an attorney's fees clause. John has admitted he could not recover attorney's fees against Conservatory based on that note. At John's brief, pages 27 to 32, he argues that the reformation of the Joanne contract, in which Joanne was awarded $148,000, did not originate out of the original contract. I don't know what else it could originate out of other than the original contract. By the way, would you let me know when I have 3 minutes? I would appreciate that. 3 minutes. When I have 3 minutes remaining. Thank you. The Conservatory note, as John has admitted, did not have an attorney's fees clause. At paragraph 21A of John's 1.525 motion found at record 519, paragraph 21A said, is incredibly convoluted. It says, in the Conservatory note suit, defendant is also entitled to recover attorney's fees. Upon reading this, and I was brought in as the attorney's fees attorney for Joanne and Conservatory. Conservatory had absolutely no choice but to address this issue and defend this issue because we thought it was directed towards Conservatory. And the trial court found it was directed towards Conservatory. As I will explain later, even if you accept John's argument, which the court did not, and I don't believe, that it was directed to Joanne, once Conservatory sent the 57.105 motion to John saying, John, you can't recover attorney's fees against Conservatory because the note doesn't allow for attorney's fees, 57.105.4 required that John withdraw the motion. And I think the best case on point is the case of Paul versus Aberami, cited in the brief 216 Southern 3rd 647, where the fourth said at page 651, even assuming Appellee's mistake in originally filing the 1.525 motion was innocent, he had no excuse for not withdrawing it. And in that particular case, the trial court denied attorney's fees and the fourth DCA reversed based on 5705. This case is strange because John has admitted two things that absolutely require that attorney's fees be imposed. John admitted that Joanne's contract was unilateral in nature. It's undisputed that his 1.525 motion only sought fees based on the note. The court is
But why does that matter? Because under 57105's reciprocity provision, as a matter of law, it becomes a two-way street. Why does it matter?
It matters 100%.
Why?
Because if you don't ask, you don't get. In
Well,
Stockton,
they asked for it, and they said it's based upon the note.
I'm sorry, I respectfully disagree. You have to ask for both the note and 57105.7. It is not automatic.
Have you cited any case that has applied that rule to that atomic didactic of a level of precision for purposes of proper note? Sir, can I finish my question, please? For purposes of providing proper notice of the basis of fees.
There is no case.
Okay.
But the Pardo v. Let me get the case. But the Pardo case, I think, is directly on point. In that case, there was a right to attorney's fees in a contract. It did not have an appellate attorney's fees provision. The contract stated that the prevailing party was entitled to fees. Pardo sought appellate attorney's fees based solely on the contract. The Third District Court of Appeals ruled you can't just get it solely on the contract. You had to also cite 59.46, which is the statute that says if you're entitled to a prevailing party attorney's fees, but it has nothing to do with appellate fees, then you can get appellate fees. You've got to cite both. In Stockman v. Downs, which I'm sure the court is well aware of, in Stockman v. Downs, there was a contract that permitted attorney's fees to the prevailing party. The plaintiff cited the contract in the complaint. The defendant didn't cite that contract. The Florida Supreme Court ruled you could not get attorney's fees for failure because you didn't, quote, plead for fees. I respectfully disagree, Judge Lucas. If you don't ask, you don't get. I respectfully disagree. In the conservatory note case, John has admitted that even though John has admitted, and the court found, as a matter of fact, and John has not appealed, that that John was seeking attorney's fees against conservatory based on his 1.525 motion. Based on that finding by the court, you are now left with the following question for purposes of 5705. Is it frivolous for a party to seek attorney's fees based on a contract with no attorney's fees clause? And the obvious answer is, of course it's frivolous. It's black letter law that a party cannot recover attorney's fees on a contract unless there's an attorney's fees clause. This court has twice ruled under 5705, if a party admits that their motion is without merit, you must award attorney's fees. In Scher versus Silverio, 297 3rd 634, in that particular case, Mr. Scher is an attorney representing the wife. He was discharged. He files a charging lien against the husband's attorney, Mr. Silverio. Mr. Scher admitted that he did not have, that the husband's attorney did not have any assets of the husband. Despite that knowledge, he went forward with a charging lien. The trial court, of course, dismissed the charging lien because there were no assets, but denied fees. But this second DCA reversed and awarded fees under 5705. This court also awarded fees in Keene v. Bernardo. Mr. Keene sued the wrong Bernardo. He sued Bernardo Sr., but Mr. Bernardo Jr. was the one that was sued with the complaint. And when he found that out, Keene should have immediately withdrawn the complaint against Bernardo Jr., but he didn't. Even if you don't accept the admissions, and Judge Lucas, we respectfully disagree about operation of law, both parties are still entitled to fees under 5705. This court has ruled, and Ryder v. Montel cited in a brief, that it is black letter law that if you're required, that you cannot get attorney, it is black letter law that the American rule applies, and in order to recover attorney's fees based on a contract, the contract must have an attorney's fees clause. When conservatory was served with John's poorly drafted 1.525 motion, it would have been legal malpractice for conservatory to have ignored John's motion. Once John received conservatory's 57105 motion, it was incumbent for him to withdraw it. Now, he withdrew it as to the offer of judgment, but he didn't withdraw it as to the breach of contract. And as I said before, we had no choice. Conservatory had to defend this motion. If John truly believed that the motion was directed against Joanne, not conservatory, 57105 demanded that John withdraw the motion as to conservatory. That's all he had to say. Conservatory, I'm not seeking fees against you. I'm seeking fees against Joanne. John has never explained why he did not withdraw the motion. And I think he must do so in order for him to prevail. Again, I'm not going to belabor the point. Judge Lucas, you may disagree with me on my concept that in the area of attorney's fees, if you don't ask, you don't get. If you do accept my proposition that the motion's defective for not allowing both, John did file a supplemental omnibus motion. It's not a 1.525 motion, seeking fees under both the note and 57.1057, but that was filed 100 days too late. And of course, it's a bright line rule that if you don't timely file your 1.525 motion, you don't get attorney's fees. I agree. I think on the analysis, Judge Lucas, I do agree with you that the reformation of the contract had to arise out of the original contract. The distinction between Loughran and Olson and the case at bar is that in both Loughran and in Olson, the party that prevailed on a tort, whereas the party that prevailed on the attorney's fees prevailed on a contract. We prepared on the reformation of contract, which obviously is the contract, and it arose out of the original contract. Regarding John's claim for fees under 607-1604, you need to look at the pleadings. John never asked to be given canceled checks. He asked for an accounting in the pleadings. Judge Curley made a finding of fact that has not been disputed that John never asked conservatory to produce canceled checks to the director. However, Judge Curley ordered that conservatory produce 3 years of canceled checks, and then she ruled that John was entitled to attorney's fees. 607-1602, which has not been substantively amended since 1997, requires that in order for a shareholder to recover, to obtain records from a corporation, you must give 5 business days notice before the date on which the shareholder wishes to inspect and copy the records. In this particular case, as I said earlier, the court made a finding of fact he never made such a demand. Without such a demand, he's not entitled to fees. Judge McHugh, who heard the attorney's fees portion of the case, reversed Judge Curry, and she said the court, Judge Curry's finding in the amended final judgment that conservatory must turn over certain documents to John does not equate to a finding that conservatory refused to turn over the documents over pursuant to a request from John that would be necessary under the plain language of 607-1604. Your Honor, we believe that both parties are entitled to appellate attorney's fees. If in fact you reverse the trial court, which I think you must, certainly in conservatory, I don't think anyone can dispute that it is frivolous to seek attorney's fees on a contract that has no attorney's fees clause, especially when John admitted he could not recover attorney's fees on that contract. If you rule in conservatory that attorney's fees are awardable, this court, along with the 3rd, 4th, and 5th District Court of Appeals, have awarded appellate attorney's fees when the trial court did not grant trial court fees. I'm going to cite to the court the following: Bozar v. Glending, 555 Southern 2nd, 1286, Florida 2nd DCA 1990, Zival v. Chan, 535 Southern 2nd, 708. That's a 50 CA case. Moore Majority versus Broward County Chapter of Now, 608 Southern 2nd, 630. And New England Rare Coin Inc. v. Robertson, 506 Southern 2nd, 1161, 3rd DCA. In each of these cases, the trial court denied fees, but attorney's fees were awarded on appeal because the appellate court ruled that attorney fees should have been awarded because the cause of action or motion was frivolous. This court has ruled, John could argue, well, I'm defending the trial court's decision. I can't be assessed attorney's fees on appeal. But this court ruled in Nationwide Mutual Fire Insurance Company v. Voight, 971 Southern 2nd, 239. It imposed appellate attorney's fees when in reversing the trial court, saying that the attorney had an ethical obligation to confess error. Now, in addition to conservatory, Joanne has an additional right to appellate attorney's fees. If this court sustains the trial court's ruling that John cannot recover attorney's fees against Joanne, then because John has sought attorney's fees under the Joanne contract, if he prevails, Joanne is entitled to attorney's fees under the contract if Joanne prevails. I'm worried about the fact that no one else is asking questions, but I'd be happy to take any questions at this time. How much time do I have?
You have right at 5 minutes, and I've neglected to ask you whether you wanted to reserve time for rebuttal on your cross appeal. I'm perhaps that was the 2 minutes you were thinking of. But...
Well, it wasn't, but it is now.
Oh, okay. So I will save you 5 minutes for rebuttal on the cross appeal. Mr. Adams.
Thank you, Your Honor. Very briefly, when I look back at the record here, I don't think the record supports Mr. Hauser's proposition that I or Mr. DeRogers has somehow admitted that it was seeking fees from conservatory. In fact, at 904 paragraph 55 of the record, it's very clear that what we argued to the trial court was that upon careful reading of the motion, that it could be noted that we're not seeking fees from conservatory based upon the note suit. Instead, admittedly, it could have been stated more clearly, but that we were seeking fees from Joanne based on the entirety of the two suits because the Joanne note litigation and the conservatory litigation were so inextricably intertwined. And in fact, the finding or ruling on the sanctions motions, the multiple sanctions motions that were filed by Mr. Hauser on behalf of his clients in the trial court was to deny his request for sanctions. And just before the order was entered, we provided, and it's in the record, supplemental authority, the Phil Zami versus Robertson case, which talks about the fact that the trial court has this discretion to deny sanctions motions seeking fees, where the party seeking fees had a reasonable belief that there was a basis for asserting the claim. And we've asserted those bases. We, on behalf of John DeRogers, never sought fees from conservatory on the contract. We were seeking the amounts, and that's what 21A that was inside of the renewed fee motion talks about. With respect to the 607 corporate statute issue, Mr. Hauser talks about 607-1602. However, 607-1602 talking about the 5-day letter is a condition to access, not a condition to fees. And 607-1604 sub 3 clearly states that if a court orders inspection or copying of the records demanded, it shall also order the corporation to pay the shareholders' costs. That's what Judge Curley interpreted when she initially awarded fees, and that's what, so there's nothing in here about if they've provided certain notice. There's no condition inside of the fee. It's an A, then B. The A is if the court orders, and the court did, and the B is it shall. I'm looking at those particular situations. And in discussing,
well, Mr. Adams, maybe it's more of an ABC thing, right? Where if there is a demand to access records, which is denied, and then the court then orders it B, then C, the court and ultimately awards it, then C, you shall be entitled to it. I mean, when we construct statutes, we are supposed to construct them together and in order, and it does seem like the demand precedes the right to recover fees, does it not, in the statutes?
I am very familiar, as I studied Latin in high school, with the in pari materia and the statutory construction piece. And I would respectfully submit that I think 607, 1604, the fee language does not have that condition. I do think it's a condition of access, but I don't think that it's a condition in order to get the particular fee. What's interesting is it seems like Mr. Hauser is not happy with the relief that was granted. He never asserted the lack of notice as an affirmative defense, and he hasn't preserved this particular lack of notice for an issue for appeal. And so respectfully, Your Honor, I don't see the ABC as the court sees it, but I understand the court's interpretation and argument. But I think it's, when you look at 607, 1604 sub 3 is self-contained. And for that particular reason, I think that it was appropriate for Judge Curley to have initially awarded fees in that particular situation. I haven't raised this issue, but I would direct the court to the argument in our brief related to the untimeliness of Mr. Hauser's motion or Mr. Hauser's appeal. He cross-appealed on a separate set of motions. And we've talked about this in a very academic fashion, but a cross-appeal is not intended to review a separate and distinct separate judgment. And the judgments, even though they're inside the same documents, are not the same judgments. One's an issue of sanctions motions and one's an issue of attorney's fees motions. And I will refer to the court to that section of our brief rather than consuming the lion's share of the rebuttal. But the Gould and Lamb case at 36 Southern 3rd, 842 from 2010, and this court says, even though the trial court entered a single order on both trial and appellate fees, the court's rulings on the separate fee motions were distinct and independent, contained within separate paragraphs of the order. And I would submit here that Mr. Hauser, if he was complaining, if it was a mixed bag and how it is that Judge McHugh ruled on the attorney's fees issue, then it could have been a tug of war and it could have been a cross appeal. But when he's appealing the denial of his own motions for sanctions, which the court had the discretion to do and exercise, that was a separate issue that should have been raised on a separate appeal. And his choosing to file it, and we didn't wait till the 30th day to play gotcha. We appealed on the 25th day. He had 5 more days to do this assessment and this analysis. And I would submit that the sanctions appeal that Mr. Hauser has filed is untimely. And the case law we've supported inside of our brief. But
Okay, time is up, Mr. Adams.
Thank you. Respectfully request a
Mr.
remand.
Hauser.
I thank you, and Judge Northcott, if you'd be kind enough to let me know when I have 1 minute. Regarding the last argument, all of the cases cited by John in his motion that this court denied to dismiss our cross appeal dealt with situations where there was a single final judgment on the merits and a separate final judgment on attorney's fees. And there was an attempt to graft the attorney's fees onto the separate final judgment. That isn't the case in this particular case. It's one final judgment. Number 2, there was a case or a couple cases that held that even if it's from a same final judgment, you can't bring in separate parties. In this particular case, John filed an appeal against Joanne. John filed an appeal against Conservatory. So we have the same parties, same final judgment. The motion to dismiss has no merit. Your Honor, what I said in my brief is John admitted he could not recover attorney's fees against Conservatory based on the Conservatory note. The judge found that John's 1.525 motion was directed to the Conservatory note. So the operative question, which the judge never ruled on, was, is it frivolous to seek attorney's fees against a party based on a note without an attorney's fees provision? And I think it's black letter law. Of course it's frivolous. You can't get fees based on a note that has no attorney's fees clause. John has admitted that. Your Honor and Judge Lucas, I hope I'm not being disrespectful when I respectfully disagree. But oh, good.
It's every day.
Make it disrespectful.
I disrespectfully disagree.
Yeah, exactly.
We're in a court system where if you don't ask, you don't get. Yes, automatically 57105 is grafted, but you still have to ask for it. And that's the whole point. If you don't ask, you don't get.
I think my concern, Mr. Hauser, it isn't with the proposition that you're stating, it's with the particulars. I don't think there's any disagreement that you have to assert the base. The question is how many jots and tittles and dot the I's and cross the T's, how granular do you have to be in that motion? In other words, you could take your argument and run with it and say, look, any case that you don't cite in your motion for fees, off limits. You didn't put it in the notice. That's what I'm struggling with.
All right, well then let me try to unstruggle it for you.
Okay.
It's black letter law that you have to state your basis for attorney's fees in your 1.525 motion. And you have to state all your bases. The Pardo case is directly on point. The European case that I cited, the party properly and timely served the 1.525 motion. He sought it on an offer of judgment, but the motion didn't say an offer of judgment. As a result, and then he filed it a year later, a supplemental motion. The 4th District Court of Appeals denied attorney's fees. You must state your basis. And in this case, there's two bases, the Joanne note and 571057. Hopefully, that's what I'm articulating. Gee, I'd hate to waste any time. There must be something else I can say. I do think in the conservatory case, there's no question that he's entitled to fees. As I said, the court got convoluted in John's argument about everything being intertwined. She never, ever addressed our 1.525 motion, our 57105 motion directly. She never made a ruling that if you're seeking fees on a note that does not have an attorney's fees clause, she never made a ruling whether that was frivolous. It's my proposition. It is clearly frivolous. I give John.
Mr. Hauser, you are down.
Half, but
Mr. Hauser, this is your 1 minute warning.
Okay, well, I'm going to just sit here in silence. I have nothing else to say. Judges, thank you very much.
Okay, thank you both. In order to leave the virtual courtroom, there is a leave button in the lower right-hand corner of your Zoom screen. And if you'll click that, you'll be gone.